Well, welcome to our 650 webinar today. The federal ETS is back on the menu. My name is Ryan Parker. I'm the Chief Legal Product Officer here at 650, and I'll be hosting our webinar today. For those of you that are not familiar with 650, we are the legal technology subsidiary of the law firm Wilson Sonsini, and we take legal expertise and thoughtful technology and bring it together to make the law more accessible for businesses and for individuals. And one of the products that we put together is a return to work site tool set that is helping hundreds of businesses with the return to work. And so we have been monitoring very closely developments that have come out of OSHA and on the federal level, the state level, and the local level. And one of the things we've been following closely is the federal ETS. In fact, we've created a federal ETS module that can help businesses to create the policies that are required under the federal ETS. And we've been following both what the ETS requires and the litigation very closely. And today we're excited to talk to you about the latest developments with regard to the federal ETS. It's been a wild ride, and we may still have some exciting twists and turns ahead. So with that, let me introduce our panelists for today. We have three panelists. First, Marie Colbeth. Marie is our general counsel here at 650 and is also a vice president of legal product. Marie attended one of the best law schools in the country, clerked on the Fifth Circuit Court of Appeals, and you'll be hearing more about the Fifth Circuit later in our webinar. And then worked at BYU Law School before joining us at 650 as our general counsel and as a vice president of legal product. When she is not working on 650 webinars and projects, Marie can often be found exploring our national and state parks. She's an avid outdoorswoman. We also have Connor Christensen. Connor also attended an excellent law school, and while in law school at Brigham Young University, worked on Law X, which is a program that we run with BYU to develop pro bono legal products. Connor proved to be excellent at working with our automation system and joined us at 650 a little over a year ago. Connor is one of the driving forces behind the excellent research that goes into our products and our updates. And I was looking, as of today, we have put out 62 return to work updates, and Connor has done a lot of the legwork behind those. When Connor's not working on researching the law, he can often be found hosting or I guess participating in Dungeons and Dragons sessions with friends, or Super Smash Brothers Melee competitions. So Connor is a great lawyer and an interesting person. And finally, we have Josh Baca. Josh graduated from the University of New Mexico Law School and joined us a little over 6 months ago. Josh has been doing also a lot of the research on this project, our return to work tool set, and also our employment agreements tool set. Something interesting about Josh is that he has hiked the entire Pacific Crest Trail. That's the trail that runs from California's border with Mexico all the way to Washington's border with Canada, and he did it consecutively. So that's pretty amazing. As someone who occasionally tries to do sections of the Appalachian Trail, I'm amazed that Josh was able to cover that whole hike in one shot. Pretty incredible. So with that, we'll dive into the webinar. I know there will be a lot of questions today. We've done some webinars on similar topics. We'd ask you to put your questions into the Q&A so that we can try to make sure that we track those and answer them. I'll answer a couple questions that we get every time. Yes, we are recording the webinar and we will send it out afterwards. And we will also provide the slide deck. So you'll be getting both of those things in a follow-up email. To help you to remember some of the things that we've touched on. Some of the slides also have hyperlinks. With that, let's look at what we're going to cover. I guess I will say one more thing. The vaccine mandate certainly has been something that's been discussed by both of our political parties, and the issue has been politicized to some extent. We're going to try to just give you the facts and how they apply to the businesses, and we'd ask you to avoid sort of injecting politics to the extent you can into your questions, and we'll try to do the same. And with that, let me dive into what we're going to cover today in our webinar. First, we're going to talk about OSHA's Emergency Temporary Standard, or ETS. what is it, what's in it, and what does it require. And for some, this will be a review, but there's some really interesting aspects of the ETS that Josh is going to cover for us. We'll then turn the time over to Connor Christensen, who's going to talk about the ETS litigation. This has been a really interesting, we've seen some really interesting developments in the litigation. There are a lot of cases, and Connor will give us both sort of a historical perspective, but also a look at what's likely coming next in the litigation. And then we'll turn the time over to Marie, who will give us a real practical look at what the ETS means for businesses and best practices in light of some of the uncertainty that businesses are facing with the current litigation posture of the federal ETS. While our panelists are presenting, feel free to put questions in the Q&A, and I'll jump in and ask some questions. We'll answer some of the questions online, but we'll try to keep this as interactive as possible. We'd love to hear your questions. I know there are a lot of questions floating out there about the federal ETS, so don't hesitate to put those into the Q&A. And with that, I'll turn the time over to Josh to tell us about the OSHA's emergency temporary standards.
Thanks, Ryan. So like Ryan mentioned, I'm going to be talking to you about what this ETS is and what it really means for businesses. And so we have a lot more detail that we've gone into when we published a white paper about this ETS when it first came out in November. I've included a hyperlink in the title here on this slide. So when you get these later, you can dive more into that on your own time. So what is an ETS? It is an emergency temporary standard, ETS, and it's issued by OSHA in times of significant need, and it requires immediate action. Basically, it's just a rule issued by OSHA that businesses will need to comply with. Now, this ETS comes as a response to President Biden's COVID-19 action plan, which was issued on September 9th, and it called on OSHA specifically to issue a rule requiring vaccination mandates from large businesses. It's important to understand that there are also some state-issued rules and certain state-specific OSHA plans, but those kind of state-specific requirements will need to be at least as stringent as those ones issued by the federal OSHA. And Marie is going to talk a little bit more about what that means in those state-specific differences. So this ETS was issued by OSHA on November 5th, and it describes the requirements being placed upon covered businesses and the deadlines by which those need to be met. And as I think many of you are aware, the ETS was met with immediate resistance from businesses, individuals, and states. And in the course of litigation that followed, the ETS was stayed or put on pause until the court could determine its legal validity. And Connor is also going to be providing you with a little bit more information on that litigation stance. Now, on December 17th, the Fifth Circuit, the stay that was put on it by the Fifth Circuit was dissolved, and it permits enforcement of this ETS going forward. Now, understanding the difficulties that businesses faced while awaiting the court's decision, OSHA announced that they'll be exercising some significant discretion when it comes to issuing citations for businesses that might not be following all of their guidelines directly. And again, Marie's going to go into a little bit more detail about what that means. Now, on the next slide here, so in determining the number of employees or the covered employers, employers with over 100 employees are going to be subject to this ETS rule. And in determining what that headcount looks like, it includes all employees across all employer US locations. That includes part-time and seasonal employees, although it does not include independent contractors. So this 100 employee threshold is measured as of November 5th, which was when the date the ETS was issued. Now, if an employer has 100 or more employees at any time from November 5th forward, they are going to be subject to the ETS requirements here, even if they subsequently drop below that 100 employee threshold. And they'll be subject to these requirements for the entire time that the ETS is in effect.
Josh, let me ask you a question here. So essentially what you're saying is that on November 5th, if a company had 100 employees on November 5th and then dropped down to say 85 employees for the rest of the year, they would still have to comply.
Well, that's correct. Yes, if at any time an employer has 100 or more employees, they are going to be subject to the ETS requirements for the extent of time that the ETS is in effect.
And so if an employer, for example, hires seasonal employees, for example, and goes over that 100 employee threshold and then drops back down after the holiday season, they would still have to comply with the ETS.
That's right. Yes. Yes. So now we discussed who's covered by this ETS, and now we can talk a little bit about what's actually required by the ETS. And essentially, it requires these businesses, these covered businesses, to establish, implement, and enforce a written policy that requires all the employees provide proof of vaccination, or if they choose to remain unvaccinated, that they submit to at least weekly COVID-19 testing and wearing a face covering at all times they're in the workplace. Now, while businesses are not going to be required to pay for testing, should employees opt for that route, they are permitted to provide certain kinds of testing that might be more convenient, particularly for data collection reasons, like on-site testing or pooled sample testing. And these things can make it easier for companies to collect the data because they would be able to get the information, the data directly from the testing site or facility. Now, test results can be collected in a variety of ways, but the one that we suspect is going to be most common is that companies will likely assign an individual or a particular department to be responsible for test collection. And identifying who is responsible for that kind of collection of data and how that kind of data needs to be communicated from employees to employers is going to need to be part of that written policy that's distributed to your employees. So on the next slide here for leave requirements, businesses are going to be required to provide certain paid time off. So in order to remove barriers that might prevent employees from being vaccinated, the ATS requires that employers provide a reasonable time, up to 4 hours of paid time off for employees to get each primary dose of a COVID vaccine. So primary dose means for Johnson & Johnson, that's just going to be the single dose that it comes with. And then for Moderna or Pfizer, each of the first 2 doses. This ETS came out before boosters were more readily available, and so it doesn't really address that, although we may see some significant changes regarding that as time goes on here. So employers are also going to be responsible for providing paid time off to recover from side effects of the vaccine. And employers can limit that amount of time, but again, it's referred to as reasonable, and that's what needs to be provided. Although OSHA has indicated that providing 2 days of paid time off is generally going to meet that requirement. Yeah, and on our next slide here, so there is certain information that needs to be provided to employees under this ETS, and it requires that employers provide the new policy that they're creating in a language that they can understand and at an appropriate literacy level so that each employee understands what they're being told here. Now, what that also means is you may need to develop and hold a couple of versions of this policy. If certain employees, may not speak English as well as others, you might need to distribute 2 kinds of policies, one in perhaps Spanish and one in English. Now, employers must specifically provide information about their policies and procedures for, COVID testing and face coverings for unvaccinated employees. There's a list of certain things that need to be provided to all employees. And like I mentioned before, I hyperlinked in the title of that first slide our white paper, and you can go check that out to get a better detailed view of this. But some of the information that is necessary to be provided for your employees is 1, the policy. 2 is there's a CDC document called The Key Things to Know About COVID-19 Vaccines, which highlights the efficacy and safety of the current vaccines that we've got, as well as you'll need to provide information on possible criminal penalties that might be associated with providing false vaccine information. And again, that list is gone into a little bit more depth on our white paper. Now, I think on the next slide here, record keeping, employers are going to be responsible for maintaining records of each employee's proof of vaccination and their COVID-19 test results. So employers, they'll need to maintain a roster of all employees' vaccination status and the basis for any employee's status as unvaccinated. For instance, if an employee has a religious exemption and they can't be vaccinated, that will need to be noted on this roster. And these records, all of these records that we're talking about here need to be maintained as employee medical records. And they can't be released except to the individual employee themselves or their designated representative, or upon request from an authorized representative of OSHA. These medical records need to be maintained separate from the employee's personnel file. And there are certain dates that are otherwise associated with holding these kind of records. But for now, what we see in this ETS is that these employee records need to be maintained only as long as this ETS is in effect. But I think Maria is going to talk a little bit more about that as we go forward. And with that, I think I will turn the time over to Connor to give you a little bit of the lay of the land of the litigation landscape.
And Josh, I'll jump in here just quickly. A couple of times you've mentioned our 650 white paper on the ETS. And if people are interested in finding that or finding out more about our ETS module that can help companies to create their own ETS policy, they can visit www.sixfifty.com/ETS. And there's more information about the ETS resources that we've created to help companies understand their requirements under the ETS. With that, I'll turn the time over to Connor.
Thanks so much, Josh and Ryan. I wanted to include this first slide before actually digging into all of the legal mumbo jumbo and information, just because even as someone who's legally trained and went to law school, this whole system can be pretty complicating and confusing. So on the left here, we can see a pretty basic representation of the federal court system. At the very bottom, we kind of have our miscellaneous military courts, tax courts, all that stuff that we don't really care about. District courts are usually your first level of entry into the federal court system. However, the way that OSHA was written and put into effect, you actually get to skip straight to the appeals level. So that's why pretty much everything we've heard about comes from courts of appeal. And the only thing above them is the Supreme Court, which is something that we're finding we're running into very quickly. On the right side is a basic map of the district courts of the circuit system in the United States. The two to pay special attention to that we care about right now are the Fifth Circuit and the Sixth Circuit. So there's a bunch of circuits involved, but we care about those two as we talk about them. So we can jump first off into a basic timeline of what's going on here in the next slide. We talked about it, November 5th. That was the big day. The ETS was released and almost immediately everyone sued everywhere. The first big decision that came out was November 6th from the Fifth Circuit. And in that case, they quickly kind of preemptively stopped the ETS and then later put a little more of a permanent hold on it, or at least a legal stuff's weird. It's a stronger temporary hold, but the thing was these cases were happening everywhere, and the decisions were probably going to be different from all the different courts. So the Judicial Panel of Multi-District Litigation took all of these cases and sent them to the Sixth Circuit, and that was on November 16th. December 17th, the reason we're all here is because that Sixth Circuit released an opinion overturning that Fifth Circuit's pause, and the ETS is now back on the menu. So it's been a very quick process of events. It was released in November, and over the course of a month and a half, we've flip-flopped back and forth on what's going on. So let's dig a little bit into what the Sixth Circuit actually had to say about the issue. It was a 2-1 decision by 3 judges, so it wasn't a single judge in this instance, and they decided to lift the pause on the ETS. The main focus, and again, if you really love reading, you can go read the dozens of pages from the Sixth Circuit, but of the many arguments, the focal point was how likely the future of this lawsuit will happen. So will they win or will they lose? And the court found that the ETS will probably win. So that's why they decided to overturn the Fifth Circuit's decision. Important, we put the word likely here. This is the Sixth Circuit's opinion, and they verbatim called out the Fifth Circuit in their decision. So there is clearly disagreement on what likely is. the main points on which the ETS kind of hangs are its constitutional authority, because it involves interstate commerce. So that's the constitutional authority of the government to act. The statutory authority is pretty much the law that created OSHA. And the court looked at whether or not the ETS and what OSHA is doing falls under that law. And then lastly, what the standard or the requirements are for an ETS. For the ETS to be, for an emergency standard to be used, the burden is actually a grave danger is the burden that they talk about. There needs to be some grave danger that OSHA is trying to prevent. And this grave danger point's really a really beautiful way to exemplify how divisive and disagreeing the Fifth and Sixth Circuits are on this. In the next slide, I actually have a few quotes pulled from their decisions. We can see in the next slide that this grave danger standard, on the very first page, the Fifth Circuit just dismissed it, essentially. They're giving their reasoning for putting the ETS on hold. They said, because the petitions give cause to believe that there are grave statutory and constitutional issues with the mandate. Whereas the Sixth Circuit said, it's difficult to imagine more OSHA could do to justify its findings that workers face a grave danger in the workplace. So you see, of those 3 points, the Fifth Circuit's really focusing on that statutory and constitutional. And of course, they dealt with all of the issues, both courts did, but we see how they kind of, the Fifth Circuit said, what's grave here is the laws and the Constitution. And the Sixth Circuit said, what's grave here is COVID. So there's obviously very valid disagreements to have over this. I included this quote at the bottom just because it's so funny. The Sixth Circuit has the advantage here because they got to respond to the Fifth Circuit. But you can see that the Fifth Circuit said that occupational safety administrators do not make health policy. And the Sixth Circuit responding that said that the Fifth Circuit had forgotten that OSHA stands for Occupational Safety and Health Administration. So you can see they're literally just catty, just quips here and there. And we can talk about what's going to happen in the future. Luckily, the Supreme Court, where this is headed, tends to be less catty, a little more even-headed. So what's happening now that we have this Sixth Circuit decision? Again, within an hour, people had already filed an emergency petition. So everyone's just chomping at the bit to get something in. We all know something's going to happen. We don't know when it's going to happen. So already this is going to head to the Supreme Court. It is going to be going to Justice Kavanaugh. And the reason that is because he oversees the Sixth Circuit. So going to Justice Kavanaugh, this isn't the final Supreme Court's decision on what's going to happen. This is their preliminary pause. It's because to have a whole court case deciding all of this will take a lot of time. So they're saying, please make a fast decision, and Justice Kavanaugh is overseeing that. The date given for that is December 30th. That's the due date for everything. And we don't know exactly when the decision is going to come out after that, but sometime after the 30th, and that date is subject to change. Now, I think a lot of people see that Justice Kavanaugh is in charge of this, and they probably quickly do an association of politics, and they say, okay, this is probably how this is going to end out. But I think an important thing to note with the Sixth Circuit's decision is that 2-1 decision was actually from one Obama appointed, in favor was one Obama appointed judge and one Bush appointed judge, and the opposition was a Trump appointed judge. So the conflict here isn't quite as clear, political, and difficult in that sense as it seems to be. But that also means that it's really hard to predict what's going to happen, and we can't say with certainty whether or not, or even likelihood, whether this will succeed or not. That's a quick rundown of what this all means. There's a lot we're waiting for, and we'll be sure to keep you informed as soon as we hear about it.
And now that Connor and Josh have really set us up with the basic information that you need to know about what's happening, why it's happening the way that it is, and what's included in the emergency temporary standard, I'm going to talk a little bit about what that means for your businesses now. And so, of course, the first thing for us to think about is that, what does this mean for us from a deadline perspective? So most importantly, be aware that this means the emergency temporary standard is in immediate effect. Because of the timing of when it was passed, the dates for it to become effective passed while we were in that pause during the litigation, but no changes to the actual deadlines were written in or are accounted for in the statute. So it's already in effect. Recognizing that that's really problematic from a practical perspective, OSHA has told us, like, look, we're going to work with companies, we're going to do the best that we can, you know, to get this regulation going, but to make it happen in a way that, you know, allows companies to ramp up now that we had this pause. So because of that, they have said, OSHA has said specifically that if a company is exercising reasonable, good faith efforts to come into compliance, that OSHA will not issue any citations for non-compliance until January 10th. So essentially you have until January 10th to get your written policy out there to get going on this. They've also said that they will not issue citations for non-compliance with the testing requirements specifically until February 9th. So while that might seem a little odd, the idea there is that, you know, the vaccine is now generally available for anyone who has not been vaccinated who wants to become vaccinated. So between now and January 10th, you can get your vaccination policy in place, disseminate it to your employees, and say, like, we've got to be on track, you know, for compliance with this today. So it's out there, it's been published to our employees, and we're starting to collect all the information. The testing side might actually be a little bit more difficult from a practical perspective, just because we've started to see some, in different parts of the country and things, some problems with getting good access to testing. There's starting to be lines, there's starting to be wait periods. So they're sort of extending that, like, okay, if that's part of your policy and you haven't worked out all of those kinks yet, we're not going to cite you for those kinks with the testing part until February 9th, if you're trying, right? If you're making that good faith effort. So January 10th and February 9th are your two big dates to have in mind. Keeping, of course, in mind the fact that OSHA has explicitly said they're going to work closely with companies to make this work. So if you have, you know, some small non-compliance issues that are more the effect of, you know, the bumps in the road of implementation, that's going to be much less problematic than if you've just done nothing. If you've, you know, made public statements that you're not going to do anything, those types of things are where you're going to really have problems first up. So those are your first dates. The second set of dates that I wanted to highlight for everybody are dates regarding the fact that the ETS is a proposal, as Josh mentioned, for a permanent standard. So this is an emergency standard, but it's acting as a proposal for a new permanent standard, which means that for the permanent standard side, we have what's called the traditional notice and comment period. So we're in that period right now. So, you know, if as an employer, as an individual, in whatever capacity, you want to bring your insights, bring your thoughts, bring your experience to bear on the issue directly, you can submit comments to OSHA. We've given you the link in the slide deck here and the docket number that you need to include in your subject line if you go to that page where you would submit your comments. So the deadline for submitting those is January 19th. So just keep that in mind if you want to be involved in the legislative process. If it's frustrating you, if it's, you know, if you're having issues, or if you've had a really great experience and want to share some best practices, please feel free. I like it when people participate in rulemaking. So those are the upcoming deadlines. With those in mind, I have seen multiple questions in the chat, and we regularly get questions about this from companies who come from states that have their own state OSHA plans. And so we did want to briefly address state OSHA plans. If we could advance to the next slide. What you see here is a map that shows you with the color code what type of plan your state has. So on this map, if you're in the light gray color, that means you're following federal OSHA. The deadlines I just talked about are your deadlines. If you're in a dark purple state, you have a state OSHA plan, which means your deadlines may be a little bit different. You still need to start planning for these, but you may have some differences. And then the really, really dark gray, almost black states here, you do have a state OSHA plan, but it's only for government workers. So if you're a private employer, you need to act like you're in one of the light gray states. You need to follow federal OSHA. Because, as I mentioned, the original deadlines have not been amended, the states who have their own state plans are already overdue technically for telling OSHA how they are going to meet these guidelines, because state OSHA plans are required to be at least as protective as the federal OSHA protections. So in order to do that, they're required to say, hey, federal OSHA, this is what we're planning to do 15 days after OSHA issued the original ETS. And then they were required to put that into place 30 days after, which would have been on December 5th. Because of the stay, because of the litigation, states haven't really done that. So what we are going to see in the coming days are states getting those plans into federal OSHA. So you may have slightly different plans in some of your states. Some of you already do have plans that have been submitted because the states were already on track to follow the federal guidelines, but expect to see some changes. But even if, like I said, you have a state OSHA plan, it's going to have to be at least as protective. So you should be planning to comply. You should be putting your written policies in place because at a minimum, it will be at least as protective, but it might be more protective than federal OSHA. A good example there is California. Cal OSHA has had its own ETS in effect for the last year, and they are pushing an amended version of it that goes into effect on January 14th. And there's some things in there that are more protective than what's in this federal ETS we're talking about. So for example, the new Cal OSHA that goes into effect in January takes away some of the different ways that it used to treat vaccinated versus unvaccinated workers, where, for example, if an outbreak happens at a business in California, the business has to do testing for all employees, not just for the unvaccinated employees. So you may have something more protective in your state coming down the pipeline. And then also I have seen a few questions about, some states have restrictions on asking for vaccination information from your employees. And if you're in a federal OSHA state, federal OSHA is going to preempt there. If you're in a state OSHA state, you should expect to see a change in your state law because you do have to meet these OSHA requirements. We'll probably also see some litigation, but just keep that in mind. Follow the state requirements for now, but you need to start making plans because those state OSHA plans are going to change. So with that in mind, your next steps as a business. The ETS, you have to first of all determine whether it does cover your business. So are you in a federal or state OSHA state so that you know exactly what you're trying to comply with? Do you have 100 employees nationwide? And another question to ask is whether you're exempt. Now, this is an interesting question. Essentially, the only reason, if you meet the other requirements, if you're in a federal OSHA state, if you have 100 employees, the only way you might be exempt is if you're covered by a different rule. So if you're covered by the healthcare COVID ETS that was issued in the summer, or if you're covered by the federal contractor vaccine mandate, those are exemptions in the federal ETS where you have to meet those other requirements that specifically apply to you because of your industry versus the more general one that applies to large employers generally. So that's really the only way you might be exempt if you meet the other standards. So first things you have to do, as Josh mentioned, you've got to create a compliant written COVID-19 policy. Then you need to communicate it to your workforce. This is the most important step. If you have the policy, but nobody knows what your policy is, there's no way you can be compliant. So you have to communicate it to your workforce and be prepared to implement it starting January 10th. With that, as you create your policy, you're going to need to start gathering vaccine status information and develop your vaccine roster for your company, keeping in mind that that roster needs to account for all of your employees, even those who are not being vaccinated. So if you have a vaccine or test policy that you decide to implement, you do need to, on your vaccine roster, list those employees who are not being vaccinated as unvaccinated. If you are, if you have a workforce that, you have people who are requesting exemptions for exempt purposes, you do need to have on your roster that they've got an exemption. So you've got to account for everybody on that roster. And then you also have to determine how you're going to train your workforce on complying with the rules. So starting your information campaign early is really key here. I don't think I can stress that enough. We're going into the holidays. A lot of employees are going to be out between now and the effective date of January 10th. And if you have employees that need to become vaccinated who aren't yet vaccinated, getting them alerted early so they can start making those appointments, so that they can get ready, so that if you do have some sort of like hybrid or other accommodation that you're providing until they can get vaccinated, or I should say a remote accommodation, you can work that out as part of your policy. And then honestly, if you are going to be offering a testing option to your employees, researching practical solutions to what that looks like where you are, because the options are really different in different places right now in terms of what is readily available, how could your employees access it. You need to look at, understanding from an HR perspective what your insurance plan is covering, because your employees are going to ask you those questions. And you need to be able to give them good information so that you can roll this out as smoothly as possible. It's already going to be onerous and burdensome from a record keeping and many other perspectives. So we want to make it as easy as possible by planning ahead for these things. So with sort of those overall best practices, first steps in mind, I did want to talk a little bit more specifically on a few of these. One is the written policy. So we've given you here a list of things that it's got to include at a minimum. But one thing I wanted to point out is you may be in a situation where you essentially have two policies. You may have a policy in place that has a vaccine mandate for all employees and you're not offering the testing option because you're not required to. However, if you have some employees who claim exemptions, then you also do have to have an alternate policy in place to govern those employees. So, if you have exempt employees, you are going to have a testing policy in place for them unless they are completely remote, for example. So you may have to have sort of this dual policy situation potentially. So that's an important aspect of the written policy. Clarifying how you're collecting vaccination status from your employees and how you're storing it is important. In some states, in addition to following the ETS generally, you also need to think about other rules that you have to follow regarding employee privacy. So California is, I think, the standout example here, which is, in California, you're required to give your employees notice about what kind of information you collect from them and why and what you do with it. So you need to update your employee privacy notice in California if you're going to start collecting vaccination information and you haven't updated it yet to reflect that. So there may be some other written things like policies outside of just the ETS policy that you need to update regarding employee handbook and other types of policies. Information that you're giving to your employees, in addition to giving them copies of the written policy, you're also required to respond to them and give them access to their own records if they ask for that access. And there's requirements on the timing of what that looks like, and that has to go into your written policy. And then a lot of other relevant information. So things like, what's your policy's effective date at your company? Who does it apply to at your company? You might have subcategories of employees it doesn't apply to, right? Some teams may be entirely remote, and so this isn't going to apply to them. They count when you count how many employees you have, but if they're entirely remote, they do not have to be subject to the vaccination or testing requirements. So, clarifying that for your employees so they know which category they're in if different groups of employees are being governed by different policies. All of those things are really important parts of the written policy.
Maria, I'm just going to jump in because we have had a flood of questions. I think we're up to almost 40 questions, and a lot of them have involved this idea of remote workers. And so I want to just sort of tee that up and maybe have you repeat what you said. A lot of the questions have said things like, if our entire workforce is remote, what are our obligations under the ETS? Or if we have employees who are entirely remote, what is our obligation towards those employees?
Yeah, that's a great question. And it's interesting because if you have an entirely remote workforce, but that workforce is over 100 employees, this law still applies to you because that employee count doesn't care whether they're remote or in person. It's the overall employee count. But in terms of when you implement the policy, who is covered by it, that's where being remote comes into play. And keeping in mind, this has to be a fully remote employee. So if nobody's coming into your work site, but they are going to client work sites where they interact with other individuals, they're not a remote employee the way that the ETS envisions the word remote. So, if you're sending your people out and they're going to a construction site, or they're going to a school, or you're a vendor that sends people places, those people are not considered remote, even though they never come to your work site, because they're interacting with other individuals as part of their work. So keeping in mind who is and is not remote, if your employees are entirely remote, then they are not required to be vaccinated or tested as part of this, but you still have to have a written policy. You still have to comply with all of these other steps. So while they may not have to, actually turn in their vaccination card, you have to have a policy in place that would, give them instructions on how to do it. But that policy also says this is who it applies to. So it's a weird sort of situation. But the good news is, if you want to bring those employees back at some point to the work site that have been fully remote, you've got the policy in place and you're ready. Does that sort of hit the majority of the questions you've been seeing come in, Ryan?
Yeah, thank you, Marie, for kind of hitting on that interesting nuance that remote employees do count towards your employee count, but are not considered covered and that they don't have to be vaccinated or have the test being fully remote. Another interesting question that I think relates to some of the things you just said was a question about employees who are mostly remote. And I think the question seemed to be maybe asking whether an employee can be moved from remote to covered back to remote, or how that would work with an employee who's mostly remote but comes into the office occasionally.
Yeah, if they come into the office occasionally and you have a mandatory vaccination policy, they would need to be vaccinated. But if you have a vaccinate or be tested policy, because again, as a company, you can choose, right? If you have that second version, they would need to be tested if they weren't vaccinated, but they wouldn't have to be tested every single week. There's the ETS accounts for, within a certain number of days of when they come in, they need to be tested. So, you could, test those employees on a less regular basis that's connected specifically to their work schedule. So the ETS accounts for that. If you're one of our customers, our tool accounts for that for you, and it gives you all of those deadlines and those windows for you. But yeah, the ETS does think through the nuances of that. And with that, I'll just also say, I'm going to reiterate a point that Josh made that's a best practice, which is you have to make this easily available to your employees. And it does need to be in the languages that you typically communicate with your employees. And so if you typically give notice to your employees in both English and Spanish, you need to give them access to this policy in both English and Spanish. If you typically give notice in both English and French, I'm from Louisiana, give it in both. So keep that in mind as we talk about communication. This is really key. Some communication is required by the ETS. So, when we talk about, you have to disseminate your written policy to your employees. And some of what's in the policy is required by law. But some things that you might decide to require may not be required by the ETS. My company currently requires that we fill out a daily screener if we come in. So it's not just about whether you're vaccinated, it's about whether you passed a screener that asked about symptoms. And that screener is not part of the ETS, but it's considered a best practice. So we have to let our employees know, hey, that screener requirement is still in place because we have decided as a company to keep it in place for various reasons. So, the written policy requirements, plus if there's anything else you're doing, your employees need to know about it so that they're following everything they're required to do. Procedures they need to follow, these are just really basic things your employees need to know. But something that I consider a best practice when you give information to your employees is to tell them, communicate to them any mission or value-based reasons that your company has for making decisions it makes beyond legal compliance. So telling your employees, look, we're only asking you about your vaccination information because we have to. That sets an expectation that if the ETS expires, or that, if ultimately the court decides that they're going to get rid of it, that you will have to stop, your vaccination policy. But what if the truth is your company is also like risk averse and, you know, very employee health aware, and you want a vaccination policy? Well, if you've communicated to your employees that the only reason you have it is because of compliance reasons, and those compliance reasons go away, you're in a tough situation. So, you know, being clear with your employees and helping them understand all the value considerations, I think can be a really good best practice that will give you the freedom to make the choices that you as a company want to make, not just the choices you have to make for legal reasons. So that's also something that's related to the idea of updates with COVID policies. You know, the law is always a little bit behind the experience. And so we see continual legal changes anyway between your local, state, and federal guidelines. But there's also, you know, Omicron just happened. That happened after the ETS was drafted. And if you want to adjust your policy to be more protective, perhaps, than the ETS requires you to be, you know, communicating these values to your employees can help you do that more easily, and help them understand why it might change more often, because we know it will change, right? The ETS will change. Dr. Fauci just said this week, hey, we might see a situation coming soon where to be considered fully vaccinated, you actually have to have been boosted. Well, that's not accounted for in the ETS, but it might be something that your company needs to account for later. So, you know, this is a best practice consideration. And then on record keeping, Josh sort of already outlined the majority of this for you, but I did want to sort of drive home record keeping requirements apply to all the medical records you're collecting. So that's, you know, vaccination status, that's a medical record under both OSHA and the Americans with Disabilities Act. Testing results, those are medical records under both OSHA and the Americans with Disabilities Act. Screeners, those are interesting. If they're self-screeners, they're medical records under the Americans with Disabilities Act, but not OSHA. But either way, confidentiality requirements apply to them. Anytime the ADA applies, you have to make sure you're keeping these medical records separate from the regular personnel records, and that you're limiting access to them to employees with a need to access those records. There's a 1-year record retention rule for the ADA. So with everything we're talking about that's a medical record, you've got to keep it for at least a year. If somebody gets discharged, it's a year after the discharge or a year after the creation of the record, whichever's later. With OSHA, we have this nice sort of breath of relief exemption, which is, although it's still a medical record under OSHA, the 30-year records requirement, record retention requirement won't apply to these vaccine records you're collecting. So that's nice. But you still have to treat them with all the protection of medical records generally, although you'll be able to get rid of the vaccine records once the ETS expires. So record keeping best practices. There you go. And then after that, I just wanted to briefly touch on face coverings. So the ETS has requirements for face coverings for your non-vaccinated employees. So if you have employees that either have exemptions or you're offering the vaccinate or test option, those who are choosing to test instead of report their status, they would all need to be wearing masks while indoors, with some limited exceptions that we've outlined. However, a non-ETS best practice is that if you don't know which employees are vaccinated, so there may be some people on this call that are not covered by the ETS, so you may not be collecting your employees' vaccination status. If you don't know, treat everybody as unvaccinated. So, you know, have everyone mask, have everyone social distance. That's just a best practice, because you are still required to provide safety in your workplace, whether or not you're covered by the ETS. And so, you know, mitigating hazards is still your responsibility as the employer. So keep these best practices in mind. Sort of one last comment related to masking best practices is currently 79.8% of counties in the United States are at a high or substantial transmission level for COVID. And when you're at that transmission level, the CDC best practices say everyone should be masked indoors in public spaces. So keeping that in mind, if you want to check your county's transmission levels, there's a little link in the slide deck that we're sending out where it says online tool. You can go check your counties where you have employees. So just keep that in mind, because like I said, best practices may sometimes require you to do more than the ETS. The ETS is a requirement But if you are paying attention to other things as, you know, the situation changes wherever you are, your best practices might change with it.
Yeah, Maria, I'll jump in. We had a lot of questions too about New York's vaccine mandate for private employees. And it's certainly more expansive than the ETS in that it applies to all private employees. And we've had a number of people say, well, which one do I have to comply with? I think it's interesting to think about the federal ETS almost as a floor, right, where it sort of sets a baseline and states are free to go above that baseline, either through their OSHA or through other state law. And so I don't think there's necessarily a conflict between the federal ETS and New York's law. I think New York's law it is consistent with the federal ETS, even though it's broader in scope. Is that how you'd read those two?
Yeah, it is. I think it's helpful to think of it the way you might think about other legal requirements that we've seen during the pandemic, which is, you know, local guidelines can always become more strict. They can't become less strict, right? So if your state says there's a statewide mask mandate, your locality will at least have to have a mask mandate. But if the state gets rid of the mask mandate, your local, right, your local city or town could still say, well, we still have one. So you can always be more strict, but you can't be less strict. And the state OSHA plans, so if you're in a state with a state OSHA plan, it's the same idea, right? You have to be at least as protective as the federal rule, but you can't be less protective. So there's a couple of additional slides that are just more informational about some best practices, what to do if you test positive and things like that. But I think this is actually really a great time, Ryan, if we want to spend some more time on Q&A. Those slides are, like I said, we've got a really deep slide deck for you. We put a lot of info on it. We broke all those rules about keeping your slides nice and clean, because we knew we'd be circulating it to you and you'd want to be able to check the info.
Well, Marie, we've actually had over 50 questions submitted. We've been furiously typing to try to answer them, but there are some really interesting ones. One that jumped out, and there are a couple iterations of, is what should businesses do if they have offices in multiple states? Some states that may be subject to the federal ETS, some that may be subject to a state OSHA plan. Do they need to have separate policies? Do you think one policy? What do you think is a best practice in a situation like that, where a business maybe has offices in jurisdictions that have different requirements or may have different requirements?
Yeah, that's interesting, because some of those different requirements could actually conflict with each other potentially. So I would say as a floor, if one of your jurisdictions is in a federal OSHA state and you want to treat your employees the same across the board as much as you can, that you could implement, you know, a written policy that's consistent with the ETS. But you have to pay attention while you do that to what's going on at the state level, because I'll give as an example, the state of Montana. The state of Montana currently has a rule in place that you cannot ask your employees, right? Like, you can't have a vaccination requirement at your company. That is a direct would be a direct violation of the OSHA rule. But if we look at the state of Montana on our little OSHA map, you would see that it's a gray state. So they're federal OSHA. So that conflict, it's like, nope, we got to follow federal because we know federal OSHA covers Montana. But if you're in the state of Tennessee, Tennessee has a state OSHA plan and it is a similar rule. It's like, oh, well, what if one of our locations is Tennessee? Federal OSHA isn't in effect there. We don't yet know what the Tennessee state OSHA plan will be. What do I do? So in those situations, I say, like, you need to have some carve outs in your plan, at least temporarily, to say, like, you know, this is our requirement. However, if you're a Tennessee employee, and then you come up with your alternative. The alternative might be, like, we're not going to put this into effect until we have an effective date from a state OSHA plan from Tennessee. Alternatively, it could be, if you're a business that can have remote workers, it might be your Tennessee workers are all on remote status until we know, right? You could do things to account for it to where you could technically be covered by both rules. It's like, okay, you know, anybody who's fully remote isn't covered. Perfect. Everybody in Tennessee is remote now. But that's tricky, right? It is tricky. And so if you're in that situation and you're really unsure, it might be a situation where you want to talk with counsel. And that could be a good example of one.
Yeah, thanks, Marie. And I think that's a great point. You know, if you have offices in different jurisdictions, you may need separate policies depending on what the laws are, or at least appendices to your policies to make sure that you're meeting the right requirements. You know, a jurisdiction that we saw a lot of questions about in the Q&A is California, which came out very early with their own OSHA's ETS that were very stringent. And we had questions like, is this written plan different than the CPP that's required in OSHA? And I think the answer there is that OSHA will need to change its standards to at least comply with the vaccine mandate portion of the federal ETS. Now, there are other parts of OSHA's ETS that are above the standards of the federal ETS. For example, OSHA requires employees to be screened before they come to the office. And so I think California companies, for example, may want to wait for OSHA to amend their ETS to bring them into compliance with the federal ETS, and then they could come up with a policy, a CPP, a COVID prevention program that will meet the state plan, which will have incorporated at least the federal standards. Is that the way you'd think about that for California?
Yeah, it is. And I think that's, something to keep in mind. We just saw, in addition to New York, we now have, Chicago and some other large metro areas putting in place vaccine mandates. So, you may need to make some of those little tweaks, whether it's California or a different jurisdiction where you have employees, like you may need some of those appendices. And that's one of the things that I think is nice about our return to work tool set is we give these updates on all of the local laws because it does get confusing, particularly for multi-state employers.
So we just have one more minute. I'll ask you two other questions. We'll see if we can answer them quickly. I had someone say they think they're going to reach the 100 employee mark in March. Once they do, how much time do they have to comply? I thought that was an interesting question. I'm not sure it's one that I saw addressed directly in the ETS, but I thought I'd ask our panelists if they know what the answer might be to that one. Once you hit that 100 mark, how much time do you have to put in a policy and get your testing and vaccination requirement in place?
I'll say it's interesting because I know that as soon as you hit the 100 mark, you become a covered entity.
Yeah.
But I don't know that there's actually a on-ramp for timing of that. I don't know if one of my other panelists has a more detailed answer than mine on that.
I thought it was a great question. I didn't see anything, and I think OSHA may be looking for reasonable efforts again there. And then the last question I thought we could address, someone said they work in a shared office building where one of the companies has over 100 employees and the other does not. Would both companies have to meet the ETS? And I guess my take on that is that it's per company. Even if you're in a shared office space, that's not going to affect your employee count that you're looking at company. But are there any other aspects to that I should be thinking about, Marie?
Only if it's a shared space where it's really one parent company. Mm-hmm. So like say you're two separate companies, but you actually share a parent, and that parent company uses the same methodology, policy, response team for all of its hazard mitigation. And there actually is a section of the ETS that says in those situations, you could be treated as one company. So if you think you might be in that case, that's a good one to go look at the FAQs on for the ETS to get some more definitive information that's reflective of the actual situation that your company's in.
And with that, I think we'll wrap things up. We got well over 50 questions. We tried to answer as many as we can during the webinar and also typing up answers. We'll finish answering the questions and we'll send the questions and answers out with the recording of the webinar and the slide deck. Again, if you have additional questions about the federal ETS, we have put together a white paper that is available at www.SixFifty.com/ETS. Also, if you're interested in our federal ETS tool set that can help businesses to create the policy that's required by the ETS, you can sign up for a free product demo there on that page as well. I want to thank Marie, Connor, and Josh for all the time they put into preparing and for their presentations today. There's a lot of information there. We will continue to have webinars on this topic. We anticipate having one early in the year. We know there's a lot of questions and there are still a number of different things that are left to be sorted out. We hope this webinar has been helpful. We wish you all happy holidays and hope that you will join us in the future for another 650 webinar. And with that, we'll sign off.
Everybody.